Welcome to S&C's podcast series, S&C Critical Insights. I'm Michael Loughlin, an associate working in S&C's Tariffs response team and national security practices. Today we're covering recent developments relating to tariffs, starting with the much-discussed Supreme Court decision, then really diving into considerations around tariff refunds and what may come next. With me today, I have Eric Kadel and Andrew DeFilippis, and I'll pause now so they can both introduce themselves. Eric?
Thank you, Michael. This is Eric Kadel. I'm a partner in the firm's Washington, D.C. office, one of the co-heads of our national security practice, and also a co-head of our tariffs response team, along with my colleague Andrew, who will introduce himself now.
Hi, everyone. Andrew DeFilippis. I'm a partner in our New York office. And in addition to heading up the tariff response team, I'm a member of our national security practice and our criminal defense and investigations group.
All right, thanks, Eric. Thanks, Andrew. Let's get into it. So, Eric, I know a lot has been said about the Supreme Court's decision in learning resources, but I'm wondering if you could bring us up to speed there and set the stage for our discussion today.
Sure. Thank you, Michael. On the Supreme Court decision in learning resources, there's been a lot of ink spilled and a lot of material recorded about that decision. I won't get into all the nuance of the various opinions in that decision, and hopefully you can find that elsewhere if you haven't caught up to speed. But essentially, the critical holding for the rest of our discussion today is that the court decided that the authority under which the Trump administration had been using to issue various tariffs that have been a central part of the Trump administration's economic policy did not, in fact, authorize the president to impose tariffs. So what that means is that the tariffs that were enacted solely on the authority of the International Economic Emergency Powers Act are no longer permitted to stand. What the Supreme Court did not do, however, was decide what are the next steps. The Supreme Court instead sent the case back to the lower courts to figure that out. Specifically, the Federal Circuit initially, and then the Federal Circuit sent that back to the Court of International Trade, where the Supreme Court did conclude that the Court of International Trade has exclusive jurisdiction over these tariffs disputes.
So the court said nothing about refunds, is that right, Eric? And do we have a sense of where we think they might land if they tried to address that question?
Thanks, Michael. Yes, that's correct. The court opinion did not say anything definitive about refunds. There were some discussions in the oral argument of the case before the opinions about what might happen in the event that the court were to conclude that the International Emergency Economic Powers Act did not provide the appropriate authority for tariffs, but no mandate on that point was issued in the court's opinion. What the precedents generally say is that there's a strong legal basis to claim refunds in circumstances where a tax or tariff was assessed and then later determined to be unlawful. But no specific process was outlined by the Supreme Court in their opinion. So that's been left then to the lower courts that received the case back on remand. Judge Richard Eaton from the Court of International Trade was designated to handle all IEEPA refund-related claims. The lead case was originally known as Atmos Filtration versus the United States. That is no longer the case, as Atmos Filtration settled, or we don't know if they settled. They dismissed their case voluntarily, and the dismissal was upheld. But we don't have knowledge on why they decided to voluntarily dismiss their case. In any event, they've been replaced as the lead case plaintiff. And what steps have been taken at the Court of International Trade so far? On March 4, Judge Eaton initially ordered a broad and immediate refunds. The order effectively instructed the CBP to immediately decline to assess IEEPA tariffs on any entries for which initial estimated duties had been paid, but that had not yet been fully liquidated, meaning had a final tariff amount assessed by the CBP. And Judge Eaton's order was later amended to include all entries for which IEEPA duties were paid, regardless of liquidation status. The Court of International Trade decided that it maintains authority to issue universal nationwide injunctions relating to tariff refunds because of their special circumstances. There is Supreme Court precedent about district courts generally and issuing universal nationwide injunctions that suggests, or more than suggests, that district courts don't have that authority, but this is a special circumstance, and we'll see if that issue gets appealed down the road. Judge Eaton himself stated that he thinks the refund process should take place pretty smoothly and that all are entitled to refunds regardless of whether they filed a claim with the Court of International Trade. On March 6, the CBP indicated to the court that it was working to set up a modified refund functionality in their automated customs environment, or the ACE platform, which they're aiming to have ready for use within 45 days. The government and Judge Eaton disagreed over whether importers have to file a claim in the court to receive a refund, but that issue is still sort of pending. Upon receiving the declaration, Judge Eaton suspended the prior order regarding immediate liquidation and provided for the CBP to provide updates to the court on a regular schedule. The CBP has since filed 3 updates suggesting it's made substantial progress on various aspects of the new functionality. And as of March 30, the statement is that they are between 65% and 85% complete. And Judge Eaton has also issued orders that are clarifying his expectations regarding payment.
Thank you, Eric. So I guess we can turn to Andrew now. The administration, it seemed like, initially indicated that refunds might not be forthcoming particularly quickly, but with this new development at the CIT, it seems like they're changing their tone a little bit. I'm wondering if you could discuss this CAPE functionality a little bit and what we've seen from the declarations that have been submitted there.
Sure, Michael. And just to cover your first point, it is the case that immediately after the Supreme Court decision, the signals from the administration were that they might litigate or challenge the prospect of issuing refunds in connection with the IEEPA tariffs. So you had the U.S. Trade Representative who said that we will need the court to tell us what to do. They've created a situation where they struck down the tariffs and gave zero guidance on this. The president himself referenced litigation in court over the refunds. And so the initial signals were that there might be a legal fight over this. The more recent signals, though, that Eric was just talking about in terms of customs and border protection are that at least at the customs level, they are preparing to issue refunds through the functionality that Eric mentioned. And so there was a bit of a shift in kind of the prognostications about whether the administration would issue refunds or not. And of course, we still don't know for sure, but Customs at least is working to build that functionality.
Thanks. So what do we know about this functionality so far? I know they provided a few updates. Does it seem like all refunds will be automatic? Will some be treated differently than others? Do we have any insight at this point?
So CBP has signaled that they are well along in setting up the functionality, anywhere between 65 and 85% complete in implementing various aspects of the CAPE platform. But they have also made clear that not all claims will be covered through what they're referring to as phase 1 of the functionality. And in particular, claims that have already finally liquidated. And that's kind of a term of art that we can explain, but refund claims that have finally liquidated will not be included in this first phase of the process. You may ask, what is liquidation and what does that mean? Liquidation is basically where customs makes a final assessment of the amount of tariffs that are due. So when an importer brings goods into the country, they initially pay an estimated tariff, what they think the tariff should be, and then it takes about a year for customs to formally review that entry and impose a tariff or provide a refund if there was an overpayment or assess a further tariff if there was an underpayment. And so shipments or entries that have reached that final liquidation phase are not going to be included in the first set of refunds through the platform. And so that's the answer to your question, Michael, of where we stand in terms of the portion of the refunds that'll be covered initially.
Got it. And then I know there have been some developments, almost procedural developments at the CIT just this week, which Eric alluded to earlier. Can you just provide a little insight into what's going on there and then how Judge Eaton has reacted?
Yeah, so as Eric mentioned, the original case, Atmos Filtration, which seemed like it was going to be the case in which all of the refund related rulings would be issued by Judge Eaton, for reasons that aren't known yet, the plaintiff in Atmos Filtration dismissed their claims this week voluntarily. And so as of yesterday, Judge Eaton appears to be focusing his future rulings on refunds and his kind of nationwide solution to the tariff refund questions in a different case, and that's called Euro Notions Florida. The judge has essentially replicated the order that he originally issued in the filtration case regarding instructions to CBP, and he has also replicated his most recent order, which required CBP to provide an update by April 14th on the status of the CAPE platform implementation. So as far as we can tell right now, it looks like the Euro Notions case has been subbed in for the Atmos Filtration case as the place where these issues are going to be litigated and play out.
There's this concept of liquidation and what happens after liquidation. And Judge Eaton, on one hand, is having customs develop this automated process, the CAPE process, but has also indicated that he's anticipated the normal process should be followed. Can you just walk through again how the normal process would go? Is there an administrative appeal, a protest, I guess it's called, and then how it could eventually get to court normally if CBP didn't have this in place?
Sure. So as I said before, typically an importer will pay a duty that's really an estimated tariff when goods first come into the country. And then after 314 days have passed, liquidation occurs and customs imposes the final, or what they view as the final tariff amount. The importer then has 180 days in which they can file an administrative challenge, what's referred to as a protest of the particular tariff or duty assessed. And then CBP has 2 years to essentially respond to the protest. Now, a protest is an agency challenge. It doesn't go to a judicial body. It doesn't go to a court. But once CBP has finally denied a protest, at that point, the importer can file a court claim with the Court of International Trade, which is the U.S. federal court that handles trade-related claims. And so that's the general process. If an importer or a company wants to dispute something that the customs agency has done or ruled with regard to a tariff.
That sounds like kind of a long, pretty drawn out process that would have each person or each party appealing and litigating. So it makes sense that they're trying to develop this more consolidated functionality. But we've never seen anything on this scale before, or anything close, I don't think, between 130 billion and 170 billion in refunds. And there have been some past examples where they've tried this consolidated refund issuing. How has that gone in the past? Do we have a sense, Andrew?
There have been varied results and pretty widely varying results. So in the late 1990s, early 2000s, there was a duty that was assessed and found to be invalid that was called a harbor maintenance tax. In that case, Customs and Border Protection set up a refund process. And for that entire process to play out was about 7 years. I think there are a lot of importers currently awaiting refunds who hope that this process does not take 7 years. But there have also been instances where it's occurred more quickly. There was a tariff or duty assessed pursuant to something called the Generalized System of Preferences in 2018. And in that case, a process was set up. It only took about 3 months. And then more recently, last year, the administration issued guidance that clarified how its various new tariffs either stacked upon each other or didn't stack upon each other. And when they clarified the rules there, that required refunds. And that process actually occurred quite quickly and was done largely electronically. So I think the past doesn't really give us a reliable guide in terms of how long this could take.
So there's some uncertainty here. There's a ton of money at stake. And I guess that gets us to our next question or topic, which is Eric, I understand a market is developed for these claims and refund proceeds. Could you talk about that and what we're seeing?
Sure, Michael, I'm happy to do that. So essentially, what you're talking about is a situation where, for reasons that you typically find in other contexts, you might have somebody who owns a claim but doesn't want to wait for the period of time that it will take to receive payment on that claim. So they want to monetize the value of that claim early. Or perhaps they also are not 100% certain that they're going to actually receive payment on that claim. So they want to monetize it for the value that they can obtain and transfer the risk of non-receipt to another party. In the tariff context, it's a little bit hard to do this claim sale, at least in a way that provides full assurances of a true sale, only because there are some rules that may influence the ability of a tariff claim holder to allow somebody else to substitute in for them vis-a-vis the government as the true claimant. What we've seen, though, is some market-based creativity where various investment firms, maybe private credit, maybe in some cases banks or other investment funds, are thinking about purchasing these claims where they will provide cash now at a discount to face value of a claim in exchange for whatever is received on that claim in the future. They can't outright purchase the claim and step in vis-a-vis the government as the true claim holder, but they can set up different protections and structures so that they're entitled to what the claimant eventually receives. There's no quote system or absolute true reference that you can look to look at pricing, but some indications that we've heard about in the marketplace for these sorts of claims is that before the Supreme Court decision in Learning Resources, the sort of going rate from various financing parties was about 15 to 20 cents on the dollar. So if you had $1 of tariff claim where you were looking for a refund, there might be a financing of that claim for 15 to 20 cents. And that made sense that it was a lower amount because the Supreme Court decision hadn't yet come out and there was no guarantee that there would be refunds at all. After the Supreme Court decision in Learning Resources, that market price reportedly approached something closer to a 50 to 60 cents on the dollar. And then after the court proceedings at the CIT on remand, and then the CBP declarations that were filed in that Atmos filtration case, the market price has reportedly climbed up to something closer to 70 to 80 cents on the dollar. Claims that we've heard about or seen in our practice are generally being structured as contracts between a buyer and a seller that give the buyer the right to receive refund proceeds when issued. But as I say, there are a number of different approaches that we've seen being taken in the market, because by taking a contract that provides an entitlement to a payment when received, the purchaser is taking credit risk of that party, and they're looking for various ways to offset that credit risk. So among other things we've seen is a requirement to pursue administrative and or litigation remedies to ensure that refunds are received, looking to obtain power of attorney for purposes of pursuing refunds, a consultation or a right to obtain or give approval from the buyer on any post-sale litigation steps to recover refund proceeds, also significant due diligence and review of documents in order to assess the entitlement to a tariff refund and also to assess creditworthiness, and various other structures that are designed to try to help mitigate this credit risk that is taken when the purchaser is unable to step in fully vis-a-vis the government as the entitlement holder to a refund.
So I think that gets to this concept of the Anti-Assignment Act. And Andrew, I don't know if you want to discuss that in a little bit more detail, which has kind of guided some of the comments Eric just provided, and then maybe discuss some additional considerations that we think market participants here have in mind.
Sure. So, Michael, the Anti-Assignment Act, which you mentioned and Eric alluded to, is a U.S. federal law that prohibits a transfer or assignment of any part of a claim against the United States or of an interest in the claim. Basically, it prevents you from allowing someone else to step in your shoes when you are owed money by the government. And so the issue that that creates is that for hedge funds or other investment vehicles that are looking to essentially buy the rights to the proceeds of these refunds, they have to be careful about not violating the Anti-Assignment Act. And really what it becomes then is a contract about what the importer or the seller of the claim does with the proceeds of the refund. So the gist of the Anti-Assignment Act is that only the person or entity that is owed the refund can actually receive it directly from the government, with a couple exceptions for things like customs brokers and other parties. But that's the Anti-Assignment Act. And so any of these contracts will have to be scrutinized carefully for compliance with the Anti-Assignment Act.
Got it. I know there's some additional kind of considerations that we've heard people really focusing on. One is interest, which we understand accrues, but there's other kind of concerns related to retroactivity of tariffs and accounting issues. On top of that, Andrew, I don't know if you can discuss this new litigation that we've seen, these class actions relating to the refunds and how those may or may not pose a wrinkle as people think about these tariff claims.
So recently, we've seen a series of putative federal class action lawsuits filed against big companies who paid the Trump administration's recent tariffs. And these are consumers who are claiming that any refund proceeds that these companies get should be paid back to consumers who, according to these claims, paid the tariffs through increased prices that the companies passed along to them as customers or consumers. And so it's an interesting legal theory in which they're basically claiming that companies do not have a right to keep the refund proceeds, because they ultimately passed along the cost to consumers. And so companies like FedEx, Costco, and others are facing these lawsuits now. And so it's another, as you say, wrinkle or complication for companies that are thinking about selling or buying refund claims.
So this kind of covers refunds, which is one set of issues. But I understand the administration has indicated it anticipates collecting a considerable amount of tariff revenue, even after these IEEPA-based authorities are no longer available. Do we have a sense of what they have in mind? Andrew, I know they put in some new tariffs under Section 122 the same day the Supreme Court struck down the IEEPA-based measures. So I don't know if you could talk about that a little bit and what else we might see on the horizon.
Sure. So Section 122 is a provision in the Trade Act of 1974 that authorizes the president to deal with what it calls large and serious United States balance of payments deficits. And there's debate among commentators right now about exactly what that refers to. But in essence, this statute allows the president to impose tariffs for 150 days unless Congress extends the time period in order to address balance of payments deficits. And so that is the provision that the president relied on immediately after the Supreme Court's decision in imposing a 10% global tariff, which was really intended to partially replicate what had previously been called the reciprocal tariffs under IEEPA, the law that the Supreme Court held did not authorize tariffs.
So in IEEPA, a question seemed to be, did Congress authorize the tariff authority? And here it seems like the focus may end up being more on, is there one of these large and serious balance of payments deficits or serious balance of payments problems? Is that a fair kind of distinction?
Yes, and in fact, there is already litigation challenging the president's use of this authority. And so we will have to keep an eye on that. Although at the end of the day, the president's authority only extends initially 150 days. So by July, Congress would have to renew the tariffs or they will no longer apply.
So these are only for 150 days. So after Section 122, what could come next? What else do you see in the administration's bag or pocket, so to speak, that it could use to replicate tariffs that it had in place last year and early this year?
Sure. Thanks, Michael. There's a few other statutory authorities for tariffs. None of them are perfect for what the administration wants to achieve because they're tailored, but there are potential uses of these other authorities. The first, and one that the administration has already spoken about using, is Section 301 of the Trade Act of 1974, which grants the U.S. Trade Representative the authority to investigate and attempt to remedy unfair foreign trade practices through the use of tariffs and other trade restrictions. Such unfair foreign trade practices can encompass violations of U.S. trade agreements and/or acts, policies, or practices of a foreign country that are unjustifiable or unreasonable and that burden U.S. commerce, including market access restrictions or other hurdles to U.S. exports. The USTR can self-initiate a Section 301 investigation, or it may open an investigation because of a petition from an interested party. But Section 301 generally is meant to be country specific and does require an investigation and report by the USTR. On Wednesday, March 11, USTR Greer announced the administration was initiating investigations into more than a dozen country economies under Section 301 for excess capacity. And on Thursday, March 12, USTR Greer announced that the administration was initiating investigations into 60 economies under Section 301 for failures to take action on forced labor. So they are looking at using this authority to issue tariffs As I said, it does require an investigation and a report prior to initiating any sort of tariffs, but that is an authority that may be relied upon, and in fact is relied upon for certain tariffs that are in existence today, including some that relate to Chinese goods. There are two other authorities worth mentioning, although they have not yet been invoked, to my knowledge, by the Trump administration. One is Section 232 of the Trade Expansion Act of 1962, which was passed during the height of the Cold War and authorizes the Commerce Department's Bureau of Industry and Security, in consultation with the Department of the Defense, or Department of War now. When the statute was passed, it was the Department of Defense, to investigate whether the importation of a particular product threatens the national security of the United States. And if the investigation reaches an affirmative conclusion, the president has authority to restrict imports to address that national security threat. Then there's also Section 338 of the 1930 Tariff Act, which grants the President of the United States the authority to impose new or additional tariffs of up to 50% ad valorem on imports from countries that have discriminated against U.S. commerce as compared to another foreign nation. Specifically, Section 338 allows the President to issue a proclamation to impose duties on imported goods from nations that apply any unreasonable charge, exaction, regulation, or limitation on U.S. products that is not equally enforced on similar products from other countries, or that discriminate against U.S. commerce in a way that disadvantages it compared to the commerce of another foreign country.
So we've got Section 122 through the summer. Then there's, I guess, some indications that Section 301 could play a role in addition to existing measures already in place, including, I guess, some under 232. And I realize we're getting to the end of the session here, but Andrew, if the administration wants to make sure these tariff revenues stay high and all tariffs are collected, do you think enforcement could play a role? As a former federal prosecutor, maybe you could provide a sense of how this priority has been outlined by the administration over the last 15 months.
Yeah, Michael, and just very briefly, I think the bottom line is that the customs and tariff enforcement environment has completely changed over the last year. And that is because both Customs and Border Protection, or CBP, and the Department of Justice have made very clear that it is a top enforcement priority. In fact, at the Department of Justice, they have named tariff and customs fraud as their number 2 corporate criminal enforcement priority. They've launched Trade Task Force that is looking specifically to build these kinds of cases. And there are a number of cases that have been brought over the last year involving intentional misclassification of goods, undervaluing goods, falsifying country of origin, and other kinds of misrepresentations that can show up on a customs form. To your question of whether heightened enforcement will play a role in increasing or maintaining customs revenue, I think it's unclear at this point, but it's certainly plausible that with the Supreme Court's decision and the IEEPA tariffs off the table, it is certainly plausible that the administration could seek to keep its revenue numbers higher by bringing more cases to recover underpaid duties and tariffs. And so definitely a heightened enforcement environment.
That makes sense. So I think we're at the end of what we were planning to cover today, and this has been great. So Eric, Andrew, thank you for the insights, and thank you to everyone for listening to S&C Critical Insights. For more information about our practice, please visit us on the web at www.celcrom.com. Specific to tariffs, we have a tariff tracker that records developments, and we put out regular alerts and memos on these topics. Just recently, we published an alert on recent developments related to Section 232 tariffs on metals and pharmaceutical products, and I'm sure there'll be more to come. As the landscape continues to evolve, our multidisciplinary tariffs response team provides integrated advice on a variety of these matters. So again, thank you for listening. Please let us know of any questions and have a nice day.